The H-1B visa is the most common way that foreign professionals come to the United States to work legally. The H-1B requires an employer to sponsor the foreign national for a specialty occupation, which means a job that requires a specialized degree, and the foreign national has that specialized degree. The hardest part of the H-1B is that they're limited in number. There's only 85,000 available every fiscal year, but the demand is in the hundreds of thousands. So the government is forced to conduct a lottery and pick out the 85,000 winners each fiscal year. But it turns out that Congress decided that there are 4 particular organizations that should be exempt from the annual cap of 85,000 H-1Bs. Government research organizations, nonprofit research organizations, universities, and nonprofit organizations that are affiliated with the university. These 4 organizations are exempt from the annual cap, so they can always file an H-1B for a qualified foreign national. Now, what's interesting about the law is that the cap-exempt H-1B is not only available to those 4 organizations, but it is also available to any company, even a private company, if the foreign national already has received a cap-exempt organization. So consider this. A company wants to hire a very valuable foreign national. Let's say it's a chemical engineer, and they want this particular chemical engineer, but the only solution is H-1B, and there are no H-1B visas available. What does the company do? Well, it turns out if a university or a nonprofit affiliated with a university will hire that foreign national for part-time H-1B work, let's say 10 hours a week, to do professional H-1B work that truly requires a bachelor's degree in a specialized field, and that employer files for a cap-exempt H-1B because they can, and the U.S. Immigration Service approves that cap-exempt H-1B, well then, suddenly, any private company is able to piggyback on top of that cap-exempt H-1B and immediately file for their own cap-exempt H-1B, even though without that situation, the same employer could never file for a cap-exempt H-1B because they're not one of the 4 designated cap-exempt employers. Well, this is a very interesting solution for so many people. It's created much discussion and excitement among immigration attorneys. Our law firm has particular expertise with cap-exempt H-1B visas for the following reasons. I personally have created 2 different cap-exempt employment situations. In 2015, I conceived of and helped implement a program called the Massachusetts Global Entrepreneurship in Residence Program, which has become a wildly successful cap-exempt H-1B program in partnership with the University of Massachusetts. Following up on the success of the Massachusetts Global Entrepreneurship in Residence Program, in 2018, I started my own nonprofit organization, which is doing terrific things to help immigrants all over the country. But I realized that a nonprofit organization is one of the cap-exempt H-1B organizations if it has an affiliation with a university. So after we had established the nonprofit, we reached out to 6 universities here in Massachusetts to see whether they would be interested in some kind of an affiliation agreement which would help university students. And it's become a fabulous program where foreign nationals are now working as mentors to university students in the STEM fields. And now, Open Avenues Foundation is an H-1B cap-exempt organization because it is a nonprofit affiliated with universities. As such, Open Avenues Foundation is able to sponsor cap-exempt H-1Bs, and businesses all over Massachusetts and New England are partnering with Open Avenues Foundation to obtain their own cap-exempt H-1Bs based on the same model that was proven successful with the University of Massachusetts.